Good afternoon. Today's webinar is Charities Lean Forward webinar, Legal Liabilities of Board Members and Management. This webinar is jointly organized by Law Society Pro Bono Services, Charity Council, and Commissioner of Charities. My name is Serene, and I'm the moderator for this webinar. First, some housekeeping matters. Please feel free to ask questions at any time during the webinar using the Q&A button. We will do our best to address your questions during or at the end of the webinar. Kindly note that today's discussion and materials do not substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. For today's program, we will first have an opening address by the Commissioner of Charities, Mr. Desmond Chin. Ms. Kala Anandaraja will then give a short overview of Charity Directors' liabilities. We will then walk through 3 case scenarios before wrapping up with a Q&A session. I would like to invite Commissioner of Charities to give the opening address.
Thank you very much. Good afternoon, everyone. It's my pleasure to join you today. And today's topic on liabilities of board members and management is a very important one and relevant for all of you. And that is why it's the first of this year's Charities Lean Forward series. I'm glad to see that there are over 250 participants in today's webinar. And it's great to see all of you here today, even though we can't meet in the flesh. The good leadership that you provide for your charities is crucial, and it is where we will make the positive changes to the charity sector. First, I would like to thank Law Soc Pro Bono Services for co-organizing this webinar. They are a wonderful partner to work with, and we've been doing so with them for several years now. I would also like to thank our distinguished speaker and panelists, Kala, Gerard, and Paul, for taking time out from their very busy schedules to share their thoughts on how the board and management should potentially manage liabilities in their course of work, or rather, should manage potential liabilities in their course of work. I would like to share a couple of thoughts with you this afternoon, if I may. First, we know that all charities need a strong board and effective management to steward and to uphold good governance in their charities. The best ones are not just those who have a board that works well together. It is those whose boards work hand in glove with the management as well. And in such partnerships, we see 2 distinct characteristics. Firstly, a board that clearly understands what its role is. There is an absence of board overreach that stifles the work of the management team and the ability to get things done. The job of the board is to provide shared vision, strategic direction, unambiguous policies in line with charity's objectives and purpose. The job of the management team is to execute and to execute these well. So let's not mix up the 2 of them. The board has a role, and so has the management team's role as well. Secondly, we see that decision-making and the decision-making processes that are in good boards are those that are not arbitrary. Well-run charities have open and clear channels of communication. Now, there is bound to be disagreements from time to time. And in fact, I would be very worried if there were none. But the point is this. The difference is that disagreements are sorted out professionally. People in the board and in the management team tend to listen well to each other. They hold their tongue. They are non-judgmental. The issues are vigorously debated. Trust is clearly present. And everybody, whether you are on the board or in the management team, knows that the decisions that the charity is trying to come to is one that is good for the charity and not for the individual person per se. Let me move on to the second characteristic, which I think is important for good boards and good management teams to adhere to avoid liabilities. That is, you need to know your roles, your individual roles and responsibilities like the back of your hand. There are few ways in which we can end up as board members or working in a charity. I've been in this role for 15 months and I've met quite a number of charities during the field visits, and some share some very heartwarming reasons for being in the charity. So for example, one gentleman told me that he wanted to give back to society. So upon the retirement from his professional life, he has joined several charities. Another gentleman told me he had a great desire to switch from a commercial role, an entity that he was working in, to serve in a charity sector because he has had enough of working in a commercial area. A third person told me that sometimes it's because of the inspiration to do good because of life-changing event. So some of them fall sick, they recover, they have a second lease of life, they think life is short and therefore they want to do some good. All these are extremely commendable reasons, and we really applaud these people. But I have also met some board members who have told me some very funny reasons for joining the charities. So one said, actually, Desmond, I was not very keen, but my friend invited me to sit on the board. How could I say no to him because of our 30-year friendship? Then yet another one told me, rather a tad too confidently, he said to me, you know, Desmond, I've worked many years in the private sector. I'm a top executive with management responsibilities for the last 25. How difficult can it be to run a charity? I don't know about you, but after 15 months, I know it is very difficult to run a good charity. And the third one is the funniest of all. I was having breakfast with her. She wanted some advice. And after when we were down to our coffee, she told me this, Desmond, I attended the AGM of my friend's charities, but before I knew it, I was nominated and elected to be the board chair. So whatever your reasons are, it is critical that you understand your roles and responsibilities well, be it whether you're a board member or your management team. And the wisest thing that I think we can do for ourselves if we are in this role is to, one, make sure that we are properly onboarded, especially if this is the first time we are serving in a charity as a board member or as a management team member. If there is no onboarding arrangements in the charity, then we need to ask for it. And at minimum, I think we need to know at least three things. First, we need to understand what is our governance responsibilities, and we need to know them well. There are actually 9 areas in the Code of Governance, which I'm sure many of you are familiar with. And if you're not, you can find these in the charity portal. Secondly, we need to have a very clear understanding of the internal controls and policies within our charities, in areas especially like procurement, handling of documents, hiring and firing of staff, vendor management, and so on and so forth. These are the most common reasons that can get us into trouble from what I've seen in charities that do get into some fixes. If these internal control processes are non-existent, then I think we must sit down with the team and establish these quickly so that we can before we get into a fix. And I hope we don't get into a fix. Now, thirdly, if we need to have a good working knowledge of the Charity Act and legislation. I know it's boring to read all the Act and legislation, but we need to know some of it. If you do not have enough time to read through all these documents in their entirety, then may I suggest that we focus on the parts that talk about the board and management's responsibilities and the penalties for non-compliance, for misconduct, and for mismanagement. These, I think, are the most important. And I've gone through the legislation and charity, and all I remember is that the penalty is 3 years jail, $10,000 fine, and or both. That's all I remember, all right, for egregious misconduct and mismanagement and other non-compliance. All right, now on that happy note, let me move on. I think the other thing that is very useful, that apart from being onboarded properly, you can also enable and equip yourself further by attending relevant courses on charity governance, board duties, charity management and leadership, and so forth, especially if you are relatively new to the charity sector. There is a whole slew of training opportunities that are being offered by organizations like SID, SUSS, obviously LawSoc Pro Bono Services, CNPL, and so forth. Your attendance at today's webinar is testimony of such continuous education effort on your part, and I applaud you for that. Now, the best protection from liability risk is to have a well-informed board who understands its roles and its responsibilities well, and to have an effective management team who ensures that their charity is operating in compliance with all the charity rules and regulations. Let me now move on quickly to share a few things. You are not alone in this journey, so don't feel lonely. The COC's office will continue to support you in your endeavor to run your charities well. We will strongly encourage charities to reach out to our 11 shared services partners who have various training and consultation clinics offered to help you in strengthening your regulatory compliance and your effectiveness. You will be able to find a list of these charities in the charity portal or in the resource folder, which is going to be shared with you right after this webinar. These partners provide good guidance on a variety of areas, such as electronic regulatory submissions, governance-related matters, talent management, and digitalization through consultation clinics, training sessions, and webinars. So for instance, LawSoc Pro Bono Services has a group of lawyers who are volunteering to provide free legal guidance for charities on operational matters. Please utilize these services and help available. It will certainly help and strengthen both you and the charities that you serve on. In conclusion, let me just summarize quickly in 3 points what I've shared. First, do watch over your board relationships and the relationships between your board and the management team. Don't overreach. Please give clear policy guidance and directions to your management team, and I'm sure your management team will be eternally grateful to you for giving them clarity and the space to do their work. Secondly, if we are new board members or new management team and we're serving in a charity for the first time, let's get onboarded properly. Continuous learning is also a must simply because we need to keep ourselves abreast of the changes and developments on this charity front. And last but not least, running a charity is really a serious business because of 2 things. 1, donors' monies are involved, and 2, public trust is at stake. So let's make sure that when we run our charities, we don't betray either. We will not do so if we had come into the charity and serve on it for the right reasons, and if we treat the charity as we would with our own businesses. Well, thank you very much for attending to today's session, and thank you for allowing me to speak with you. May I wish you a really fruitful session this afternoon, and if I do not see you before the festive holidays next week, may I wish you and your families a healthy and a happy Lunar New Year. Thank you very much.
Thank you, Commissioner of Charities. For our next segment, Kala will provide a brief overview on charity directors' liabilities. Kala heads the Competition and Antitrust and Trade Practice at Rajan Tan and heads the Corporate Governance Practice. Kala has written widely on corporate governance, including books on the subject. She currently sits on the BCA board and is a member of the External Review Panel for SAF Safety. Kala, over to you.
Thanks very much, Serene. And just going to get my slide shared. Okay, a very good afternoon to everybody. And, it is actually a tall order coming after Desmond. He's touched on all the critical points, and to that extent, it's made my life a lot easier. Now, when we talk about director duties and corporate governance, it's not a simple 5-minute, 10-minute, or even a 15-minute session. It is a session that can go on for an entire day. In fact, when I do director duty sessions, the minimum we try and cover is half a day, simply because there is a lot to be done. However, knowing boards and knowing directors and how busy people are, we tend to sometimes compress that session. And for today's session, we're compressing it even more. So what I'm going to do really is just provide you with very quick highlights in terms of what your key duties and obligations are. Now, starting with a big picture. And if you have questions and so on, typically I would say send them through and I'll take them on, but we will pick them up during the panel discussion. So please do not hesitate to put questions through. moving back to the deck of slides, in relation to the big picture, what I thought was important to start off with is to just give you a quick overview of the kind of legislation that's out there that regulates you. And believe it or not, this list is no way complete. A lot of charities generally operate as companies limited by guarantee, which means you will be subject to the Companies Act provisions, or you could be a society, or you could be an association in some limited instances, which means the Societies Act applies. Additionally, if you're registered as a charity, then obviously the provisions of the Charities Act and subsidiary legislation under the Charities Act kick in. Beyond this, there's also the Code of Corporate Governance. Now, the Code of Corporate Governance for charities and IPCs generally sort of borrowed, in a sense, from the General Code of Corporate Governance in its original heydays, when the original Code of Corporate Governance was issued. However, it has been tweaked and made to apply specifically to charitable organizations as such. Now, over and above all of those legislation, you see that I put the PCA in, the Prevention of Corruption Act. This is a general piece of legislation, but it is absolutely critical, and people do get tripped up for violation of the PCA as well. Generally, it kicks in where you are on a charity, not for all the right reasons, and in any event, unfortunate steps are taken where monies could have been accidentally or corruptly passed through you, for instance. I'm not going to go into details about that. I'm not even going into details about a whole list of other legislation. This is just to give you a big picture sort of overview. Now, moving along, these are some of the things that Desmond already highlighted. As part of the big picture, I thought it was important to put out there that as a director, as someone going onto a charity, the critical thing you need to know is what is the objective of that charity. That will aid you in answering the question as to why are you joining that charity? Why are you going to sit on that board? So be very clear, what is this charity set up for? What is the purpose behind it? What is its vision and mission as such? These need to be very clearly expressed. And if you think it hasn't been and you're going to go onto the board, ensure that it is clearly expressed. Come back, review it every now and then, and ensure that these are documented and communicated to the public. And here I just want to tie back to a point that Desmond made as well. He said, in a sense, keeping the public apprised of the ongoings of the charity, because there is public funds involved when they donate, is very important. And so I'm putting that up front, critical that everyone sort of follows through that. Moving along, another key pointer as such in relation to compliance concerns. As a director going onto any board, a charity, all the more, these are some of the key things you need to be thinking about. Public confidence in your charity. Without public confidence, you're not going to be able to raise funds. You're not going to be able to achieve your mission and vision for the charity as well, funds aside. You need that public support at the end of the day. Making sure there's financial prudence at the bottom sort of right-hand side of the slide. Managing your financials carefully, ensuring that there are proper records of finance, and ensuring that you got the right people to manage that kind of issues, very critical. Ties into disclosure and transparency. You know, I have a very simple philosophy in life. If you're transparent about everything you do, it's very difficult to find fault in what you have done. And likewise for a charity as well. When in doubt, disclose, be transparent, regardless of who you're hiring, what your action steps are, where your funds are coming from, and so on and so forth. Then there's the element of conflicts, and I'll pick up on that in the next few slides. Corruption, I kind of quickly talked about it, but I put that down as an important consideration. Moving along with that big picture overview, I thought I'll just jump straight into directors. Who are they? What do they do in the concept of the charity? Now, if you look at the Companies Act, Director includes anyone who occupies the position of a director, whatever name called, includes a shadow director. So this is anyone who has been formally appointed to the board, anyone who can dictate how that board operates. They will be caught as a director. If you look at the Charities Act, it talks or makes reference to a governing board. The governing board is essentially the members of the governing body of a charity or trustees for a charity who have general control and management of the administration of the charity. Whilst the phrase general control and management is not used in the Companies Act, the essence of it is the same. In both instances, the board, the directors, are agents through which the charity or the company executes its actions. They are the face of the body. They are the ones who execute. We talk about management. Management doesn't really, in that sense, execute in the way I'm thinking about it. Management are people to whom the board delegates the functions, and then they go out and actually implement as such. So directors occupy a very important role in the organization, in the charity. Moving along, just from the concept of a charity or perspective of the charity, it is important that when you go in, you know your responsibilities, you know the charity, to make sure that that charity is going to be well managed, it's fulfilling its objectives. Only then will you be said to have fulfilled your obligations as such. Attending training, developing the competencies. Now, you might be an expert in many different areas, but there's certain things which are unique to the particular charity you decide to sit on. And just coming up to speed through training, through dialogue sessions is always helpful, important. And of course, keeping abreast of relevant laws and regulatory requirements, because there's constant evolution. It continues to develop. At the end of the day, another important element is exercising independent judgment, and acting in the best interest of the charity. That's critical for a director who sits on a charity. Additionally, not to be sort of ignored or treated lightly, it's making an effort to attend board meetings. Now, I've been working with boards for many years now, and I'm sometimes somewhat aghast about directors who do not make the effort to attend board meetings. If you have no time to attend board meetings, how are you going to have time to be able to perform effectively for the board, right? And board meetings are very critical because that's where all the discussions happen, the dynamics of putting out different points, crossing, discussing, and eventually coming up with a final sort of viewpoint happens there. So board meetings, absolutely critical. If you want to go sit on a board, ensure you have the time, availability, no compromise. Now with that, let me very quickly move on to key duties and liabilities. Now, the duties and liabilities that I highlight here are no different whether you are a company director, for-profit director, or a charity for non-profit director. It is about duties that come about under the common law. There are duties under the Charities Act, there are duties under the Companies Act, the Societies Act, and a whole range of different other legislation depending on the activities that you want to carry out. All said, it is really about exercising independent judgment and acting in the best interest of that charity. Some of the duties include acting in good faith for proper purposes, without conflict of interest, with due skill and care. There are also a number of administrative functions, such as putting together your annual report, ensuring your finances are properly maintained and reflects a true account of the status of the organization. So keeping that proper records, absolutely critical. Now, in the gray box, you see that at the end of the day, as far as directors are concerned, they do take risk, which no director can honestly believe to be taken in the interest of the company. So if the director takes a risk which cannot be something that he honestly believes ought to be taken, and he goes ahead and does it, that's potentially a breach of his duties, his fiduciary duties as such. Let me illustrate with some examples. Now, before I go into that, I just wanted to put out two sections. The presentation portion of today's session is a little too short for me to go into many more, but very quickly, just two sections. Companies Act, Section 156, talks about potential conflict of interest. Now, being in a position of conflict is okay. You can be in a position of conflict. However, if you fail to disclose and you go ahead and do whatever you want to do anyways, that's when potentially you're going to be in breach. And then the other, which is acting honestly and always with reasonable diligence. Acting with reasonable diligence has been time and again explained as acting with due skill and care, right? Moving along, conflicts of interest, and I don't plan to go into the cases in detail, very quick snapshots and only the really important ones that make the point clear. Now, this is not a charities case, it's a company law case where a director basically had accepted a loan from the company's customer, various materials, to be used in the renovation of his own home. Now you take a step back and you think about it. What's wrong with that? It's a loan. I'm going to pay back. It's a independent transaction. It's got nothing to do with my company, but it's the company's customer, and it's going to be done without charges, without any sort of additional payments to renovate his own home. That puts him in a position of conflict. No one is saying you can't do it, but he didn't disclose it. And that is a potential issue. So it's a very minor, seemingly minor infringement as such, but it puts you in a problem. And likewise, when you sit on a board of charity, you got to think very carefully, even if you're an expert able to contribute towards that charity because your company does something and you sort of refer your company to the charity, potential conflict there, and you really got to be very careful. Now, taking the point a little bit further, the reason I put up Mona Computer Systems here, and this is a case that went up to the Court of Appeal even. It's a case where an employee of the company decided to divert contracts from the company. Now, he claimed that there was no conflict because if he had gone to the director and told her about it, she would have said, okay. So he's guessing, right? He's guessing that the other board of directors would have said okay to him taking all of these contracts over. It's a bit of an exaggeration. The court said so. It didn't make sense. Of course, he lost. But think about the kind of arguments that people put forth, right? The next case, again, very simple instance of, and these are professionals. A doctor basically entering into contracts under a different organization altogether without first notifying her original company of it. The failure to notify put her in breach. I move on. Honesty, the second element, so conflict of interest is one. The next is honesty. Honesty is basically acting bona fide, always in good faith, always in the best interest of the company, all right? Now, when I say best interest of the company, when I say acting bona fide, honestly, in essence, if you look at the case there, look at para C, it is acting without carelessness or imprudence. You must not be careless as you execute your duties. You cannot be imprudent, meaning that you cannot not read papers, board papers before you go to a meeting, for example. Caution is absolutely critical. So that now brings me to a couple of skill and care cases. Now, this one was a charity case, and because it was hugely publicized, I put it here. It's clearly more than just a simple violation. It involved a personal executive working in the charity as well as the CEO. The CEO had issued a check, supposedly in relation to a payment voucher, to another company. The check was encashed by this executive, but it was never paid on to the other party. The CEO provided false information and tried to argue that this is not, in a sense, a misappropriation. It was always intended to be for the personal executive, and all kinds of reasons were provided. But here's where, again, regardless of the reason, and there's a lot more to this case, again, time factor. Regardless of reason, follow process, follow procedure. Do not seek to try and circumvent, take shortcuts, or I'll just go get cash and pass it on. None of that's going to work. It doesn't aid. In this case, of course, like I said, there's a lot more involved in the matter, and the CEO himself provided false oral evidence during the due inquiry matter. And the whole concept was really he wanted to extend a personal loan to the executive rather than to make that payment to another company's CEO. Obviously fraud here, but why do that? Why take that risk? Why kill public confidence? This is clearly a breach of your duty of honesty, clearly a breach of your skill and care. Now, skill and care, a very old case now, 20 years. I don't believe I'm saying this case is 20 years old, but it remains the seminal case on the point. This is Yong Peng Hao, CJ, as he then was. Essentially, managing director of 3 pawn shops, accepted jewelry to be pawned, split the risk between 3 different pawn shops. Subsequently, when the person came to redeem the jewelry, handed him a check. His mistake. He didn't wait for that check to clear. He handed the jewelry back to that individual. Skill and care breached. How can you do that in a pawn shop industry where the risk, the stakes are high, and not wait for your check to clear? Seemingly innocuous, seemingly no reason not to trust, and yet a serious breach. Obviously, the check didn't clear. And so this is a rare case where he was criminally prosecuted as well. He didn't go to jail, he had to pay a fine. Now, these 2 cases I put on to emphasize the fact that whether you are a for-profit organization or for non-profit, it is important to ensure that you review finances, the financial reports. It could be monthly statements. It is important to review board papers. Essentially, what you're looking for is accuracy, is consistency. If something is out of whack, question it. Something you don't understand, question it. If you do not review finances continuously on a consistent basis, you're not going to be able to pick up these nuances. You're not going to be able to pick up that, hey, suddenly there are all these things. Who are we paying to? What are we paying? It could be small amounts, but if you see it regularly, it is important to pick it up. And this goes to skill and care again. A failure to do so means that you're potentially liable. Now, a quick point here as well is if you try and rely on your auditors to pick it up, yeah, they have to, but then you as a director cannot absolve yourself of liability. You as a director have this obligation on the board to be reviewing all of this, which is why I stress availability is absolutely critical and you cannot run away from that, okay? And there's no issue about executive, non-executive, and so on a charity. Everyone is involved. Everyone needs to be on top of matters. Now, with that overview as such of duties and responsibilities, I wanted to put this slide out in relation to charities. One of the key things that charities do is raise funds, and Desmond highlighted a few of these pointers as well. Now, when you go out and raise funds, transparency is absolutely critical. So which means that providing accurate information to your potential donors, no two ways about it, you have to. And then of course the proper accounting of it, maintaining confidentiality of who had donated, and subsequently being able to account back for what these funds were used for. All very critical. The slides will be shared, so you will have this as well. I'm near the end of my deck. Directors must keep, sorry, typo in English. A director must keep himself informed. Desmond highlighted the fact that directors must keep themselves informed. There have been time and time again a number of cases that have dealt with this issue, and in Singapore as well, so Singapore cases as well. A director cannot say, I didn't know, no one told me, it wasn't in the papers that was given to me, the board papers that was given to me. The question will come down to, did you make the effort to find out? So if there's been a change in the law, why didn't you know there was a change in the law? If there is certain expenses being incurred, why didn't you know that certain expenses were incurred? And so on and so forth. To be able to sort of keep up, you need to know upfront what that charity is about. And this ties back to one of my early slides again. What is the mission of the charity? What is the charity trying to do? Acquire that rudimentary understanding about the charity, and then make sure you keep yourself posted on a continuing obligation, as a continuing obligation. Attend training, attend dialogue sessions, and there's so many on Zoom now all the time. Make the effort to spend that 1 hour, that 2 hours to do so. At the end of the day, if you come into the charity with special skills as well, note that that could raise your duties and obligations a little bit more. So your duties become a bit more heightened. All the more you need to make sure you're keeping up to date on those issues. So if I'm a retired individual and I'm going to join a charity, I cannot say, okay, I forget about keeping up with the law and I will just advise. No. I go in with that expertise of being a lawyer. I need to keep up with it, keep informed so that I can give my value add to the board as well as we discuss issues. All said, there is no place, whether in a for-profit or in a not-for-profit, for the concept of a sleeping or a passive director. I said that you can rely on other directors. Yes, you can, but the reliance must be fair, must be after you have asked questions, and no question is too stupid, raised doubts, ask until you get an answer you're satisfied with before you say you rely. So don't rely blindly. And if it's a third-party expert you want to rely on, make sure you check the credential of that third-party expert. Do not just hand it to any third-party expert. Make sure it's the right kind of expert that you should be passing it up to. With that final slide, I believe, always ensure that whatever you've done in terms of any expenses, finance, so on, try and put it together into an annual report, share it. It's your best way of gaining that transparency, building that public confidence. Absolutely critical. And all this because you do have a public image to maintain. Charities do a lot of good. Let us not tarnish that by making careless mistakes. I'm not saying all of us are going to be fraudulent, but I think it's important not to make careless mistakes as well. Remember, carelessness, imprudence puts us in a difficult position. Don't do that, okay? So at the end of the day, the board, you must ensure that there's proper systems in place for communication, for if you want to have information disseminated, make sure it's done through a particular spokesperson and not every board member is a spokesperson, for instance. And be careful about your logos and so on that's used. With that, I've reached the end of my slides. I'm sorry, I'm about 5 minutes overdue. I'm going to hand it back to Serene. Serene, back to you. Thank you.
Thank you so much, Carla. To discuss our case scenarios, I would like to invite Dr. Gerard Yee and Mr. Paul Seah to our panel. Dr. Gerard Yee is a chartered accountant and the chairman of the Charity Council and Agency for Integrated Care. He is also group chair of the Canossian entities in Singapore. Mr. Paul Seah is a senior partner at Tan Kok Kwan Partnership. He is widely recognized as one of Singapore's leading disputes practitioners. Outside of legal practice, Paul is the chairperson of Living Waters Methodist Church, member of the Executive Board of Trinity Annual Conference, and sits on the Board of Directors of Metropolitan YMCA Singapore. Thank you, Gerard, Carla, and Paul for joining us today.
Thanks,
Today,
Irene.
we will follow Sam's journey of being a charity director. There are 3 stages. First, becoming a charity director. Second, being a charity director. And lastly, resigning from directorship. Let's start. Sam would like to be a director of a charity. After searching and applying, he's offered to be a director of I Love Animal Charity, non-executive director of Happy Animal Charity, marketing director of a children's charity, but he does not sit on the board of directors. Sam would like to accept all of the appointments. He thinks being a non-executive director does not involve much time, and a marketing director only does marketing. Carla, are there any legal differences between the different directorships?
Thanks for that. Yes. So whilst the term used is director in, say, the Companies Act, for example, there are differences between different types of directors. In relation to executive directors, they are generally employees of the company and who sit on the board as well. So in a charity, you could be potentially one of the key executives in the charity, but you're also appointed to the board. And that's not unusual. In that case, you're executive. You're earning a salary as such. Whereas for a non-executive director, you're not typically employed by that charity or a company. Instead, you're just appointed to the board. You're non-executive as opposed to independent, because there must be some sort of relationship. Either you have a family member working in the company or there's some other connection as such. And that's why you're called non-executive. You do not receive a salary. What you receive is sometimes a director fee. Charities, generally no director fees. We're all doing it voluntarily. Third thing, marketing director. This creates a lot of confusion because it's director. So I must be a director, right? Unfortunately, not. A director contemplates an individual who has been appointed to the board. So when you're a marketing director, strictly speaking, you've not been appointed to the board. And without more, I mean, there are lots of permutations here, but without more, you're just an employee. Serene, back to you.
Thanks, Carla. I think that's very enlightening because nowadays, I think in terms of titles, the word director appears so much. You can even be a, IT director, etc., etc. So it's good to get the clarity that, as you said, you really have to look at what is the role. Is there any legal criteria that Sam must satisfy in order to be a director, like maybe a minimum age?
Good point. Minimum age, it's not expressly stated as such, but you need to be of legal age, which means 21 as a rule. Maximum age, no more. There used to be 70, but it's been taken away, rightly so. Other criteria, I think to me, availability is absolutely critical. And I say that again, having seen boards over the number of years that have been in practice as such, availability. Secondly, I think you need to have the right acumen, the right skill set to be able to be a director for that particular charity. And just because you're charity of charity A doesn't mean you automatically fit in B. There could be other criteria as well, but I would put these at the top of the list and pause there.
Thanks, Carla. Gerard, putting, I guess, legal criteria aside in terms of minimum age, for example, what do you think are other important things that Sam should consider before accepting any position?
Well, I think Carla has brought up a very important point. And the best way to articulate to the layperson is that as a director, when you sit together as a board, bear in mind it is not a social gathering, which is very different. Unfortunately, I've seen many instances because we know each other so well, that the board meeting becomes more of a social gathering, and it just lacks that professionalism. So there is that heavy responsibility. And as Carla has stressed, if you don't have time to attend the board meetings, how will you have enough knowledge to discharge your duty as a director itself? So it is something not to be taken lightly. In the example given, that individual may well feel confident and truly is able to spare the time to sit on or to hold so many positions. I think every individual has to discern for himself or herself that question. And if they're really confident about it, just bear in mind their responsibility. And if at the end of the day, they are still very confident they can give enough time and energy to discharge their duties, then by all means. But the problem here now is, in the example, you have two organizations of very similar activities. I would say disclose to each that you intend to sit on a competitor board. And if everyone is acceptable of it, your board members may not find that acceptable and then decide not to appoint you. But if they are comfortable with it, so be it.
Thanks, Gerard. I think that's such a useful point because, very often I suspect for volunteers, they're normally driven by a pet cause. And, perhaps they're very active in this example in, the animal scene and, they could receive various offers. So I think this conflict of interest points is quite interesting. And I guess on this point, Carla, is there any legal restrictions in terms of being a director of both the I Love Animal Charity and a Happy Animal Charity?
Strictly, if this was for profit, I say it's a lot tougher. Because if you're in the same business, the likelihood of potential conflicts coming up is going to be a lot more. But even in a for-profit environment as here, at the end of the day, I say that so long as you have made the disclosures, so long as both charities are comfortable with it, you don't need the consent, but if you're comfortable with it, strictly no objections. Yet, having said that, practically it's not going to be easy because the law doesn't prohibit it, but practically, one of the key things highlighted is if I'm the same charity, my pool of donors in Singapore is already very small. I'm going to keep going to the same place, and then you keep asking the same people for the same things. It puts it difficult. And how do you decide that if there are going to be two different events for each of the charities held in close proximity? How do you decide which one do you pull the funds towards or take certain steps towards as opposed to the other? So from a very practical point, it can be difficult, not from a legal prohibition perspective.
Thanks, Carla. And I think, especially if you're involved in certain pet causes, as you said, you might have the same pool of volunteers or even sponsors sometimes, or even beneficiaries, it depends. Well, Paul, you are both a lawyer and a charity director. And I guess touching on this issue where, you have the luxury of choice in terms of, being also a charity director, do you have any tips on, working professionals? Like, how do you balance your day job and charity directorships?
I think I should start off by saying it's a privilege for all of us to serve, actually. And if you have the time and capacity to give back, it's so rewarding, right? Especially if it's a cause you believe in or a cause you feel called to. But saying that, there is certain things you have to consider. And the theme that both Carla and Gerard have talked about was time. And if you want to sit on the board of a charity and serve, I think knowing your capacity, knowing your availability is very important, because there are duties that come with it. The privilege is great, but the rewards are wonderful. But and I encourage everyone to serve, but you need to know what it entails. And I would suggest that before anyone takes up a lot of us take up a charity role because a friend has asked us, right? Do you want to come and help? Or as a pet cause and we are actually looking out. Now, some of us as commissioners reach a point in our life where we think we want to give back. I always find it useful, actually, in the few charities I've joined to sit down, maybe work in the board committee first. A lot of boards have subcommittees, and see what their involvement is like. Talk to management, talk to other board members, sometimes it creeps up on you. For some new board members, they come on the board, they think maybe, okay, only we meet once every 2 months or once a month. But it turns out to be, hey, you have a subcommittee, you sit on the audit committee, the human resource committee, nominations committee, and then board members are required to or requested to come down for different events of the charity, and it builds up. So it's important to know what it entails, how much time you need. And even the board meetings, you need time to prepare. You need time to read the board papers which are prepared for you. You need time to digest them, to think of what questions. And oftentimes, you do see some board members who come in wanting to serve, but they get overwhelmed quickly. They come from meetings unprepared, and it's not very pleasurable for serving. So I think know your capacity, know your time, talk to the charity, understand what the requirements are. And there are different ways to serve. I think being a board member is extremely important because a lot of times we're brought in for a skill set or experiences outside of the charity. Carla and Gerald both mentioned that it's an important contribution. What Commissioner said, we drive the strategy, the vision, we work with management, and the board is very, very key. But that's not the only way you can serve. You can start by volunteering to do other things for charity, fundraising, being on the ground. And a lot of times we enter the board after serving the charity for some time, and to get a feel whether the vision of the charity, its goals, the way it works matches our personality. We get to know how the board functions even from the outside. And then that's a good jumping point to get into a board role if you're undecided and you're not sure.
Thanks,
so
Paul.
there are different ways to serve a charity, but once you go onto the board, then the different duties come in, and you have to make sure you have the time and capacity for those.
Thanks, Paul. I think such useful tips in that, before you jump on and being the board, you might want to do a temperature check by, as you said, there's maybe subcommittees, etc., that you can join to at least, know if your values or your goals align with the charity. After all, it's slightly different from a for-profit setting, as well as you mentioned, it's not just attending board meetings. It's not unusual for board directors to be required to perhaps head or sit on certain subcommittees. Now, we received a question from an audience member, and perhaps I'll ask it to Carla. Are there any differences in responsibilities for directors that are doing this for free?
No.
Okay.
Whether you're paid or it is for free, the fact that you take on the appointment brings on the responsibilities. And when it brings on responsibilities, it means you have to act right. And if you make a mistake, potential liabilities can come on. Obviously, it's defensible. I mean, how and why the mistake came about and so on. And we'll not go into that here. But free or otherwise, liabilities abound. So do be cautious.
Thanks, Carla. And I think that's a good reminder to everyone, even if you're being a director for free or maybe a very low remuneration, the liabilities are still the same. So let's move to the next scenario, where Sam becomes a director of I Love Animal Charity. Now, volunteer requests to increase the operating budget by 10% so that the charity can switch to another brand of animal feed as it is more nutritious. Board is asked to approve. Sam is uncertain as he does not have much knowledge about animal feed. Well, Carla, in an ideal world, board members would be knowledgeable in all aspects of a charity and its operations. It just happens in this case, a director encounters an issue that he's unfamiliar with. Can he rely on the volunteer's advice?
So if you go back to my deck of slides, I said reliance is possible. But is reliance on just that one volunteer sufficient? I would be hesitant. What I would do is, if I was on the board, I would take a step back and say, I don't know very much about this. How do we know that it is indeed better food? How will it really help the animals sort of be better? And I would ask for more information, more evidence. And here, it's not just a volunteer, here management, there should be management. Management should be able to look and answer these questions for me. At the very least, provide me with sufficient literature. And then we should have a discussion at the board. Now, am I making much ado about nothing? No, because it is a 10% increase in the budget. That is a lot of money. regardless of how big or small your charity is, 10% is a lot. So I would want to be cautious. And I repeat again, no questions too stupid. So don't rely straight away, ask more, ask.
Thanks, Carla. Gerard, any thoughts on this?
I think Carla is absolutely right. We have that responsibility to do our homework. I actually went through this experience when I stepped into NKF. It was my first involvement with the healthcare sector. And I couldn't even spell, I couldn't even remember the term hemodialysis and peritoneal dialysis, but I had to get research, speak to doctors and try to understand it. Otherwise, it's difficult for me to appreciate why it costs so much to build a dialysis center, why we have to spend so much on the piping to make sure there are no right angles in the pipes to prevent sediments from forming, why we have to spend so much on special filters to make sure the water is absolutely pure. You know? And once you assume that position, along with it comes that responsibility to understand as much as possible about it and not to just because someone told you it's right that it must be so. You need yourself to be convinced. Yeah.
Thanks, Gerard. And I think that ties back quite nicely to what the Commissioner of Charities said as well, in that, you can do continual learning, and especially if you are, trying to be a board of director for a certain charity, it's good to, as you said, and you've shown by example as well, that you yourself actually went to try and learn and read up more, about some very admittedly technical aspects of the operations. Paul?
Serene, I'll add in,
yes.
Today, the age of the internet, there's no excuse. You can Google just about anything you want, or listen to 2 or 3 TEDx presentation, and you'll get a rough knowledge of what the subject matter is about.
Thanks, Gerard. Well, Paul, do you have anything to add?
Yeah, I agree completely with Carla and Gerard. In fact, I was going to say just 3 very quick points. One, Google is your friend. Of course, be wary about fake news, but oftentimes you don't need to have complete knowledge, but there's no excuse not to read, not to find out. And one of the great joys of sitting on a board, which is outside your normal day work, is you learn. And oftentimes it might be a charity you're passionate about, and you learn about, I assume Sam is passionate about animals and he gets to learn about animal feed, right? So that's one of the great joys of sitting in a charity. You learn from other directors who are outside your normal field. And you have an impetus to go and research, to learn yourself. So Sam, in this scenario, he needs to do some reading. The second thing that Carla brought up is management. And if a charity has good management, rely on them. It's good for them also to work with the board to form their ideas, because the management needs to know these things. They are the ones who will be running the day-to-day operations during the procurement. And the board's role is really there to check, to make sure that things are done properly, but working together with the management, get information from them, ask them questions. And oftentimes you find that they are a great repository for knowledge, because this is their day-to-day job. And the last thing I would say is this, after you Google, you talk to management, this is within about 10% of the operating budget. And when you're thinking of something that big, normally there are policies involved. It may be that for something so big, you need to get 3 tenders. You can't just rely on a volunteer and a distributor. It may be that that the charity needs to conduct interviews of the different distributors or their channel. So the important thing, if you're going to spend a huge chunk of money or a huge decision, normally there are policies to guide you. And one of the questions you might want to ask is, what policy is behind this? And if you find that actually there are no policies safeguarding such large expenditures, maybe it's time for the board to sit down. There are lots of resources out there. Consult the COC, consult LawSoc Pro Bono, and come up with policies. Because if you don't have these safeguards, and you say 10% of operating expenditure is spent with just a tick of the pen, then you have to be careful. Your liabilities might come up to haunt you later. So research, management, but make sure you have sound policies and follow the policies.
Thanks, Paul.
Serene,
yes.
Serene, I think I'd like to add on something to Paul.
Sure.
A very important topic, documentation. You need to have very good processes, but charities being charities, and very often we depend very much on volunteers. We talk about things, but we don't document it. And a year down the road, nobody remembers why this decision was made, how was it made, who made it, and if ever you get into trouble, is documentation that is going to help you. The lack of documentation means you can't prove one way or another, and you're really in deep waters. So don't take shortcuts. Keep your documentation. This day, digital age, keep them safely so that you can pull it out. The emails, the minutes of meetings, don't summarize, don't sanitize it. Have it factual, and that may well save your skin someday.
Thanks,
Serene,
Gerard.
if I can just very
Yes.
quickly add to what Gerard just said, I think that is so horrendously important. Documentation. And oftentimes there are boards that try and keep minutes as minimal as possible. So really minimalist minutes, resolution, pass, fail, how many for, how many against, but without the real discussions that go into them. I personally have been a huge proponent of keeping minutes. Now, doesn't mean detailed minutes in every single discussion, but sufficient depth to at least capture the critical points that were discussed, I think is very important. So whilst we may have all the other sort of supplemental documentation, the board discussions are very important and needs to be captured. So I would stress that to all of the participants listening in today.
I echo that.
Yeah.
Having done several unfortunate charity cases in court, actually the minutes or lack thereof of the board really can sink or save the directors.
Yeah, and I want to add on, if I happen to be on a board and I disagree in general with the decision, and I've spoken up, I want to make sure that is minuted. Otherwise, later on, nobody knows that I objected to it, and the reason for my objection. Silence means consent, so you be very careful about that.
Thanks, Gerard. Thanks, Paul. I think, echoing resounding emphasis from all our speakers, that it's important to document, including disagreements. It's okay that there's disagreement. Don't be shy to document it. At least it shows some sort of robust discussion before a decision is finally made. Because I think it was earlier mentioned that, let's be realistic, in a perfect world, there's no risk doing things, but certainly we have to adjust with real life situations, and there will be risk taking. So it's really good that the board actually, sounds it out, have a robust discussion before, choosing its course of action. So moving to the next part, Sam is requested to sign a contract on behalf of the charity. Sam feels uncomfortable as he does not know if he can do so and if it's part of his responsibilities. Carla, what are your thoughts?
I'm going to circle back to something that Paul said just now, policies. It is typical for most organizations, charities included, to have policies which set out in terms of contracts, who signs what kind of contracts, what are the approval limits, and so on. It shouldn't be that Sam, particularly if he's new onto the board, that he should be the one signing all of the contracts, for instance. And if he is a board member and he signs on the contract, the immediate impression is going to be that it's been approved, it's accepted, the charity is now bound. But has that contract even been pre-discussed? Has the subject matter of that contract even been pre-discussed as such during, say, a board meeting? Has there been consensus formed towards saying, yeah, we'll go ahead with this? I think these are some important points to look at. If I take it a step further, and coming back to the point about policies, there will be certain mundane sort of matters where management will deal with all the time. Buying stationery, for example, or in the case of animals, for instance, perhaps buying feed, because I've already put the tender out, and so the regular payments and so on, management can deal with that. When it comes to a contract like this, calling for Sam to sign off on, what's the purpose? It's because there are certain limits to it. And generally, from my experience, very, very rarely there's a single board director sign off. If it's coming to board to sign off on a contract, very rarely it's a single board director. And if it is meant to be a single board director, then typically you will have a resolution sort of passed. So in the context of a charity, same thing, there needs to be that discussion and consensus that this director is going to be signing off on the contract.
So what's the significance of Sam signing on the contract? I mean, is he personally liable or it goes back to the charity?
As a general rule, it goes back to the charity, unless the charity can show that Sam had no authority. So if there are policies in place and so on, and the policies have not been complied with, there is a real risk that Sam could be potentially liable himself. So again, we need to look at a series of factors.
Thanks, Carla. Again, so important to set up a policy, a process, because it makes things so much smoother. And I'm sure that for charities like companies, you have a lot of contracts to sign. Perhaps Paul, are you able to share any experiences of how your charity handles contracts? Is it signed by all the directors or do you delegate?
So in general, I different for different charities, but good governance normally would mean that you have different levels of approval, and they're often tied to how much money is involved. So you don't want a situation where the office needs new correction fluid, and you have to find a board of directors resolution to sign for that. So that at the lowest level, that usually is some form of petty cash, whether a debit card or a credit card or some cash. That one, the approval could be just office manager. But you go higher up, to a certain level, the management has authority in most charities. It could be someone in the office hierarchy. Beyond a certain point, normally it takes the CEO or CFO. But then when you reach the higher amounts of expenditure, that a good policy normally states that you need someone in management and someone at the board, normally a treasurer or a board of directors or the chairperson. And if it gets a much higher amount, let's say a contract that binds the charity long term, or a very big expenditure, say a capital expenditure, you need to buy a new vehicle, you need to renovate the building, that normally needs a board resolution. And then the board will authorize someone to sign the contracts. And normally you would have a policy to get X number of tenders to make sure that the process is transparent. So it really depends on the risk, and the risk is driven normally by how much you have to spend and what responsibilities the charity takes on with the stroke of that pen. Same thing with electronic payments, which is what we do most of the time. For large amounts, it's normally a staff and a board member. And then you have to have group A, group B signatories. You can't have a few kakis or friends on the board decide to just sign. Normally you have by position, and you need someone from a certain group of staff and a certain group on the board. And I think that's sound practice. I will say that when I first started serving on charities when I was much younger, I think, oh, these policies are a real nightmare. They're boring. You have to read them. Do I really have to read them? I'm here to serve. I want to help the cause, right? But as I go along, both wearing my professional hat and having to defend charities have gotten in trouble, as well as sitting on the board, I realized that actually these are the safeguards that allow you to have a firm basis to do your work well. Do your work smoothly, and to keep you away from trouble. So sound policies are very important, and as boring and difficult as they may be to read and catch up sometimes, I think every board member, this is in a sense your safety net, and it's very important.
Thanks, Paul. Important reminder, although policies can be very long and maybe sometimes tedious, it is so important because, as you said, it really helps to streamline the processes as well as show that you've done what you had to do. Joad, so what are your thoughts?
No, Paul has just mentioned about delegated functions for ease of administration. So at the lower end, the general manager and office manager probably can be authorized to approve expenditure up to a certain amount. But how do you make sure they do not exceed, they don't keep on spending? And this is where actually every charity must ensure that they have the board approve a budget for the next financial year before it begins. And this is sadly missing in many cases because of time restriction, or they just don't have that good enough accounting function to work out with the budget. But I think it's very important. How do you operate a delegated function when there is no budget to tell those people, yes, you're authorized to approve expenditure up to a certain amount, but in total, it cannot exceed Y dollars. And you really need to have the budget approved by the board. Then the board can just allow them to function within their delegated authorities.
Thanks, Gerard. And I think a good tip, also for charities to check their policies that, when you have delegation authority, it's not only just the quantum of the contract, but it has to be in accordance with the approved budget.
Yes.
So to our next situation that Sam encounters, Sam does not receive a pay for being a director. He wishes to request for a pay or to, at least be reimbursed for his cost of dealing with the charity's matters. For example, taxi fares, phone bills, treating the volunteers for dinner, etc. Carla, as Sam is a director, does Sam have any legal rights to request for a pay or reimbursement of his cost?
Legally, strictly, no. I mean, neither the Companies Act nor any documents anywhere legislatively provides that Sam's going to be entitled to any reimbursements. In fact, historically, a director was not entitled to anything. And this is talking about for-profit directors as well in a company. And for him to even get his director fee, it's not salary, director fee, it needed to be approved by the board as a whole. So that's something which is historical and it's always continued. It's that element of fiduciary, that element of trusteeship as such. Now, if we take that a step further and look for not-for-profit organizations to seek a payment does seem a little excessive. Legally, you don't have the right, and then to go ahead and seek the payment might seem a little excessive because you're there to volunteer your time. And yet, if these taxi fares and phone bills and so on are entirely driven because of the work being done for the charity, so you've got to cart things from point A to point B, and the only way to do that is by taxi, and you don't have your own car, for instance, and it is for the event for the charity, maybe that's something that you budget for the purposes of that event, but not as a regular policy issue. That's not to say it cannot be done, but I think I would be slow to say that these should be done on a regular basis.
Thanks, Carla. And I think it's a good reminder, I suppose, for anyone thinking of being a director. Perhaps these are things you need to consider beforehand, and you can't take for granted that just because you are a director of a charity that you'll automatically be reimbursed. Paul, I think being realistic, right? Some, I think, charities or volunteers, they may not be earning much and they're really volunteering out of their passion. But sometimes, these costs do add up. And money can be a tricky issue to raise. So do you have any advice on how a director can approach the board about such issues?
Yes, this is a very tricky issue, and it is reared its head in more than one board that I've advised or sat on, because it can snowball quite fast from reimbursement for taxi fare. What happens if, as a board director, you as an international organization, then you have to fly somewhere to represent the charity, and you end up having to pay your hotel expenses and your airfare. Do you get reimbursement? What kind of airfare? Let's say all the other chairpersons around the world fly business class. You take economy. So these are questions that come up. So again, I've used the word many times, but policy is very important. And this is not only for directors. Directors will set policy for staff as well, for reimbursements and claims. Because with a charity, more than anything else, you're dealing with public money, funds raised from the public, and you have a fiduciary duty to safeguard and spend that properly. But not only a fiduciary duty, it's like you have a moral obligation, an ethical obligation to make sure that is spent well. And sometimes it's not only about making sure it's fair and proper, but you have to look fair and proper to your stakeholders as well. So my advice would be, look, money is an issue, and you find that actually the board is spending a lot of money to support the charity, and that's something which is difficult for. Be open to the rest of the board member and say, well, the rest of you may be able to afford this. I have some trouble, so maybe you can help me out a little bit here, or maybe I excuse myself from certain activities where I have to spend all money. Be open about it. But if the charity does feel that for volunteers, whether board or not, should be reimbursed for certain things, then I come back to the word over and over again. It should be a policy. It shouldn't be I spend already and I come to the board and go, hey, you know, I've done so much. Can you please reimburse me? Here's my receipt. It's good to have a policy, and then there's no quarrel. I mean, if the board sets a policy and it's approved in the AGM with your stakeholders coming in and say, okay, there's reimbursement of taxi fares, then it's clear. No one's going to quarrel about it. And then that's the proper forum for people to decide and then question the board and the members how much you want to reimburse, and then it's clear, and then you follow the policy. Better to do it then than to do it ex post facto, meaning you do it after. That causes a world of trouble and controversy. And I will say that actually in a lot of boards, these things have been done by custom, because charities start out casually, they become more formal later on, and out of habit, maybe form over decades, people get reimbursed left, right, center, and then it causes problems later on. So it's good to talk about these things and set a policy and clean house before, if you have never really talked about it as a charity.
Thanks, Paul. Important, hard but important discussions to have, and a policy does facilitate that. Dealing with this situation. Gerard, do you have anything to add?
Yeah, well, I'll add disclosure. Some of the larger charities, it is not unusual for them to send one or more board members on a study trip or study mission overseas to learn more, especially for a specialized subject. Be transparent so that your donors know how much you're spending on all these study trips. It can amount to quite a lot, especially if the director is traveling all the way, say, to Geneva or to Boston or somewhere, and does he go alone? In some cases, it may be justifiable that the board member should be supported by at least one staff who have the technical knowledge and so forth. So all this can add up to quite a fair bit. But if you disclose and your supporters are aware of it and continue to support it, then that's fine.
Thanks, Gerard. Important reminder to everyone, this is the public's money. So if you're going to, as you said, it's better to just be transparent, especially if it comes to big expenditure.
So can I just make a very quick point?
Yes.
I recognize that a lot of the audience here might be part of very tiny charities, as well as some who are part of very large charities. So we're talking about that entire spectrum. The messaging is not that even the small ones should now be sort of perhaps traveling and so on. I think we need to recognize that different charities have different requirements, and even that small taxi fare can be a substantial amount for a very small charity. So where I'm coming from is the policy is also very important for that small amount and not just the large amounts, so that there's a consistency. And it may be that it's not just for the board members, but also for management, potentially also for volunteers when they participate in activities, whether they can get reimbursements. I mean, I might be doing a cleanup job somewhere and I buy drinks for everyone as a volunteer. And I'm young and maybe in uni and I don't have money, maybe can I get that reimbursement for having bought the drinks? And it's a fair request as such. So just for everyone to think through those as well. Yeah.
Thanks, Carla. No, I think it's such an important reminder that every charity has different resources and needs and volunteers, especially if you're a charity where a lot of volunteers may not be from very well-off backgrounds. Then we just have to be conscious, that not every volunteer is able to contribute that much financially. Yeah. So we've come to the last stage of Sam's journey, which is resignation, not a topic that's often discussed. Well, Sam feels discouraged that his suggestions are often rejected by the charity founder and his friends, which form the majority of the board. Sam also feels uncomfortable that the charity awards most contracts to companies owned by the charity founder and his friends. To avoid the issue, Sam decides to resign immediately. However, the board of directors told Sam that he should serve 1 month's notice. Sam thinks that this request is unreasonable as he is not paid. Well, Carla, I mean, it's quite a interesting situation. So what are your thoughts?
I will go back to the drawing boards. Is Sam purely a non-executive director, or is he also executive? If he's executive, then what does his employment contract say? 1 month's notice, then unfortunately he may not have a choice and have to serve that out. Typically, good employment contracts, I stress good because I don't see it often enough, would not just provide about resignation from the role, the job, the management role, but also about what happens to the directorship. So that's important to check the contract. Now, if he's not an employee and he's just a non-executive director, then are there any terms of references about appointment and then when you want to leave? It's not always common to have terms of references that spell out how you can leave the board. And if there aren't any, then for him to say only as a non-executive director, so not an employee, that he's going to leave immediately, strictly nothing to stop that. Strictly nothing to stop that. So he doesn't need to give the 1 month's notice. Yet there are certain obligations that follow. If it's a charity that's incorporated under the Companies Act, so Company Limited by Guarantee, for example, he needs to give ACRA notice that he's no longer a director, that he's resigned. So that's going to be another important point, timelines and so on. Now that's going to prompt questions. Why are you resigning with immediate effect? Why no notice and so on? Now the ACRA notice, you don't actually have to say it's with immediate effect, but there is contemplation that you need to give some kind of reason at least. COC will also want to know when a director is leaving the board. So that also prompts additional issues. So quite apart from whether he should give notice or not give notice, he needs to bear in mind that there are at least 2 regulators who might come a knocking to find out why. Whilst the company or the charity bears the brunt of that, he needs to be in a position to be able to explain. And I just want to be fair to charities that the director himself cannot be seen to be overly emotional, and everyone's always talking amongst themselves. I'm kind of left out, nobody wants to take my suggestion, so I resign. You know, playing that emotional card as such, that shouldn't be happening either. So essentially, to reiterate, employment contract, there's one, terms of reference if there's one, and recognizing that notifications are important. So bear that in mind as you plan your exit as well.
Thanks, Carla. I think one, I guess, unusual aspect of this is he's trying to run away from the issue, right? He feels maybe he doesn't want to go and tell them, look, this is not right, or I feel you're breaching policies. And he's like, okay, you know what, I'm out. Is he able to escape responsibility just by just quitting quickly?
Okay, so important point here. Has something wrong been already done? If it has already been done, then he cannot escape liability. Even if he quits, the liability will find him, the accountability liability will find him. And as ACRA or COC probes some of the reasons as to why he has resigned will come up, it could prompt an investigation if serious enough. Looking at this, it's because he feels uncomfortable that contracts are being handed over to friends of the founder of the charity. So presuming that there has been no proper tender process, for example, and contracts were just awarded out, that raises questions of ethics, potential conflict concerns, and issues of whether the pricing is right and so on. I would ask the additional question of, did he probe at the time the contracts were being awarded? I mean, we don't have enough facts, but did he raise issues at that point in time that they were discussing the contracts, or did he just, or the contracts were never discussed at the board meeting and just handed out, for instance? That could have an effect on whether he potentially could be liable or otherwise. I guess, yeah, he's kind of avoiding the issue, assuming nothing wrong has happened. Does he have the added obligation of ensuring that proper policies are put in place? The answer is yes. And presumably he has tried and has failed. And that's why he wants out. If that is the course that he's taking, then again, I think not entirely unfair. But the rest of the board needs to be alert and say, what signal is this sending out to the public? What do we need to do to ensure processes are put in a proper manner? Essentially, governance. To think that the request to stay put for an additional month is unreasonable because he's not paid, non-factor. To me, that's a non-factor. I think everything else that I've highlighted and more, as Gerard and Paul will share, are some of the more critical elements that you do need to look at.
Thanks, Carla. Gerard, I noticed that, Sam's, when you look at the underlying reason of why he's quitting and perhaps why he wants to quickly run away, is perhaps he felt it's a very uncomfortable issues and, he finds it difficult to deal with an established clique on the board of directors. Do you have any tips on any new directors to boards? Like how do they deal with cliques?
Well, that's a very difficult question to answer. I think at the starting point, bearing in mind your reason for joining a board is to contribute. And how do you ensure that you're joining a board where you can contribute? And that's to do your homework and to check, speak to people who knows of the charities, speak to existing board members that you know of. And for all you know, before you even consider saying yes, you find that the undercurrents there, that the board is very fragmented, disorganized, then you may well want to consider or think twice before saying yes to joining such a board. Otherwise, you get drawn into the whole fiasco. So do your homework to start with. And there are always telltale signs. And people are willing to hint to you that, hey, maybe you should think twice about wanting to join this board and so forth. But let's say you innocently got into it and you notice all this. My only advice that I'll give to anyone is have the courage to speak up. Yeah, you have said yes, you have been appointed, you have a duty to discharge. Speak up, make sure it's minuted. And if they refuse to minute it, if it's me, I would write to the Commissioner of Charities and tell him what has happened. I've insisted on this being documented. It's not, at least it's documented is somewhere. Someone is aware of what I'm going through. Then at the end of the day, then I'll say, okay, I've done all that I can and I call it quits. Yeah, but do all this to protect yourself. So.
Thanks, Gerard. So I think in short, you can't run away or just keep quiet. In fact, it might make it worse because you are seen as, I think earlier was mentioned about just consenting because you just kept quiet when you didn't dare to speak out at all. Paul, do you have anything to add?
Yeah, I mean, governance is the governance issues are the difficult part that I hope none of our participants will have to face. But it comes up. I mean, I've been privileged to sit on charities where we haven't had to face any of these nasty issues. But on the other hand, I've represented charities and directors who've had to. And I see it as a spectrum. There are some where on boards where we often disagree on strategic vision or the way we do things. And sometimes it's just a clash of personalities. You don't like somebody, they don't like you, or it's a clique. There's a clique issue. But when it starts shading towards bad governance, for example, doing things without tenders, giving contracts to friends, or even further, you suspect that there's been mismanagement or misspending of money driven by the board, some certain members of the board. Then that's where wisdom you need to decide. Okay, has this shaded the line between disagreement on style or direction into something that's not quite right? And when it hits there, you need to do something. And the first thing that needs to happen, you need to bring it out and discuss it as a board. And you have to make your stance known. Unfortunately, it's not easy, especially for those who are introverts, who are newer to the board, who are younger, and your board members have been sitting there for 20, 30 years. It's difficult to bring this up, but that's why you're on the board. Right? And that's the difference between just being a volunteer and being a board member. And as Gerard said, if it falls on deaf ears and you find you're being stonewalled, then you have a duty to tell somebody about it. If it's financial, you can talk to your auditors and go, hey, there might be a problem here. There's always writing to the COC. So that's important, right? And I think it takes wisdom to decide where that line is crossed. But when you can see that line coming, you should already start feeling uncomfortable. And that's where I think your ears and your eyes need to be extra open. And the one thing I'll add to that also, in talking about cliques and how these things happen, I think board renewal is something that it's recently become something that we've talked about a lot about in the charity space. If a board has the same 8, 10, 15 people for the last 20, 30, 40 years and working with the same contractors all the time, it's very easy to form cliques. So actually having a policy of board renewal is important. There's a balance between keeping the institutional memory of a charity, especially for historical ones. So you need board members who've been there for some time to drive that. But the renewal, so that you don't enter the risk of forming cliques where the board, the charity, is controlled by a group of a few friends, especially when you have grown bigger and you're raising money from the public. I think that is key, and there's a wisdom that drives that. So I would encourage all boards to think about the renewal process. Are new people coming in? Is the board controlled only by a small clique of people? And good management to prevent these things like what Sam is facing from happening. Part of it is board renewal.
Thanks, Paul. And I think an audience member has asked, on this topic about renewal, any thoughts on what's the ideal time period? Like, I mean, obviously 40 years is a bit too long, obviously, but what, 2 years, 4 years, it's such a tough balance to strike, because you wouldn't want someone who just step on and then by the time they got used to it, they just step off. Any thoughts in terms of time periods? Basically, Paul and Gerard, you have any thoughts on this?
I think COC has guidelines. If I'm not wrong, and I might be wrong, so you should check. But I think I think COC's guidelines at the moment would be no more than 10 years, and then you should explain why there's no renewal, and that's sensible, because you do need that institutional memory of how things have been done and why policies are in place.
Yeah, I think Paul is right about that, and that's why I'm so big on this whole subject of documentation. And if you're properly documented and your annual reports is well written, you don't have to worry about losing track of the history and the legacy. And if there's someone that has good memories or something that they can contribute, the question is, do they have to be a board member, or can you just make them an advisor? Or if they're really big-hearted enough and say, really, I don't need a position, I'll come back as a volunteer, and if you have any question, it's the intent of serving. Why do you need a title if you really believe in what you're doing, at the end of the day? So there's really no excuse, and 10 years is pretty generous, because the world is changing so fast. A board member may be relevant today, but are they keeping pace? How many board members today can really advise the charities on the IT needs of the charity? COVID has accelerated all the processes, but I know board members struggle to log on to Zoom. So I'm not quite sure whether they can give you good advice on IT policies. Yeah.
Sorry, I was going to add to Gerard's point. I was going to make this point earlier. 10 years doesn't seem very long. To some, it might seem like, oh, but 10 years goes by very quickly. And someone who's older now, I agree, 10 years goes by very quickly. But originally, when we talk about time span, right, you look at long-term, mid-term, short-term. And the short-term used to be the 3 to 5 years. Yeah. And the long-term used to be the 20 years and so on. In today's day and age in particular, 5 years can be long-term even, depending on the nature of the organization you're part of. So to have someone who stays put for too long means that you're living with older ideas as well. And hence the duration that we talk about, and I agree 10 years generous, but still not unreasonable, should also be done on a sort of rotational basis. That means different groups renew at different points in time, so that at all times there is sufficient institutional knowledge continuing. There's always someone with 6 years as a first yearer comes in, for instance. And that's important. So it's on a rolling basis. So recognizing long-term is no longer 20 years. Long-term is very short. Yeah.
Thanks. And
Yeah,
I
I'll
think
just pick up on what Gerard said. Actually,
Mm.
the way a lot of charities are working now is to keep the institutional knowledge. We have a board of advisors or council of advisors, and the older board members. And I'm really thankful because they have a lot of wisdom and knowledge, and they agree to sit on this panel of advisors, and that can be a very rich source of knowledge. On one hand, though, they no longer have the liability, and the risk, so that's good for them, and don't have the weight of having to read the board papers and having to fulfill fiduciary duty. So that's a good thing as well on their part. Long deserved rest after the 10 or 20 years, right? But that's a good way of organizing a charity to keep the institutional knowledge and yet have the renewal and recycling the risk in that sense.
Thanks, Paul. Let's start our Q&A segment. To our audience, if you have any questions, please submit them through the Q&A button. Well, I think one question that was raised, and this is for Carla, is that you have mentioned and also referred to duties under the Companies Act for board members. So for this particular audience member, he's in the society. So he's curious for societies, what's the reference point? He's thinking it's probably not Companies Act.
Yes, correct. So it's not the Companies Act as a key reference point, it's more the Societies Act. But recognize also, so the Societies Act does have some duties and responsibilities laid out, not in the same way as the Companies Act, but there are. It has all of the administrative duties laid out as well, so you need to comply with that. But apart from the Societies Act, you do need to look at the Code of Governance for charitable organizations. So the Charity Code of Corporate Governance, important, because that actually provides a lot of guidance in terms of what, as a board member, you should be looking at doing. Now, all that aside, additionally, even if it's not looking at legislation, it's looking at common law principles. So common law principles means basically case law. And there are not a lot, unfortunately, of cases that have gone to court on charities or reported decisions as such. There are a handful, but not a lot. Now, case law will generally state that as a director on any kind of organization, you will owe fiduciary obligations. And fiduciary obligations already connote sort of a trustee relationship. I'm sort of pushing the boundaries a little bit in saying trustee, but it does mean that you must ensure no conflicts. You must ensure you always act with due skill and care. It sort of falls within that whole common law principle of fiduciary obligations as such. And hence, whether you are organized as a society or as a company limited by guarantee, be alert that everything we talked about applies equally to you. Save or maybe when you resign, you don't need to notify ACRA from a Companies Act perspective, but actually Societies Act you need to. And save that maybe from a criminal liability perspective, I think the Companies Act is a little more rigorous than the Societies Act. But don't forget, there's the Penal Code, there's the Prevention of Corruption Act, and so on, which can grab you in any event. I hope that helps.
Thanks, Carla. I think maybe to summarize what you're saying, just because it's not a company, it doesn't mean that you're in a society means you don't really have any duties, right? But
Correct.
there is, as you said, a lot of legislation you said that you can refer to.
Yes.
So quite a number of the audience members are asking about insurance coverage. I think for some of them, they recognize that you have volunteers who may not very well be well trained, and they're doing this really for the passion for their particular cause. And so that's why perhaps the charity is thinking, you know what, maybe we should buy insurance to help cover our volunteers who are directors of the charity. So I guess this is very broad, maybe more policy questions and thinking. Gerard, what are your thoughts on that?
I think growingly this is common to have a general insurance for directors, but at the end of the day, if you did something deliberately that is against the law, the insurance is not going to cover you. You're not going to get away with it. But this is just in case, in spite of all your best effort, you are being sued. At least you have the comfort that you're covered by insurance.
Thanks, Gerard. Paul, any thoughts?
No, I think it's good practice if the charity can afford it. In fact, the charity should set aside some budget. I know it's not easy because we're talking a whole range of charities here, from the largest to there might be some here representing very small charities. But as Gerard said, it's a protection. I have to make clear, of course, if a staff has been fraudulent or a director has been fraudulent and stolen money from the charity, a lot of insurance policies might not cover the loss of the money. But let's say a director is found to be negligent, you missed it out, right? That's where the protection comes in. And we, again, hopefully none of us ever have to face that, but things do happen. And having an insurance is actually quite a comfort for directors in all organizations. So it'd be useful if you're not sure whether your charity has insurance or not, to ask and to check whether there's an insurance policy.
Thanks, Paul. Our scenario touching on...
Sorry,
go on, Gerard. Yes.
I thought just strike me. You know,
Sure.
on several of the charities I'm on, the additional insurance is I appoint a legal firm and I consult them on legal matters proactively. Before I do, I say, yeah, I'm thinking of doing this. Do you see any potential legal problems in advance? Don't go and do it first, and then after that, when you're in trouble, run to the lawyer. It's a bit too late. So when it's something major, it's very useful to have your legal advisors who follows the history of your charities, who knows what you're doing, and give you the advice. It's money well spent.
Serene, if I can add to that as well, and I think
Sure.
Paul will confirm this. Legal advisors as well also do it on the basis of making sure you get the right expert, making sure you put out your tenders, and then have the legal expert. Different charities, run for a year or run for 2 years or whatever, and then renew it as well. So exactly the same process for procurement. And I agree with Gerard, particularly if you're medium to large, it does aid having counsel that you can bounce off things with, rather than every single piece that you're going to do, you go out and you got to procure and so on, but rather you have one so-called, kind of like almost an in-house counsel, except that it's external at a nominal cost, who can help you with quick answers and advice and so on and so forth. So I see this happening with the medium to larger ones actually quite often.
I give a very good common example. Many charities potentially will get themselves into trouble by having a very poorly drafted employment contract for the employees. Yes. You know, it's all a cut and paste. You Google it and cut it. Go get your legal counsel to vet through it, and that will be the best insurance you have.
Thanks, Gerard.
Yeah, absolutely. And I noticed that someone just posted in the chat what I was going to say. There's a very useful website, Resources for Charity. A lot of times because of the cost, and here, not only the small charities, actually the large ones also try to save costs. We think, okay, we can do it in-house. We have a lawyer on the board, let him comment. We have an accountant on the board, let them comment, or let our CFO do. But, you know, when they're spending things on issues of governance, sometimes it's the best insurance. It saves you a world of trouble. And as a disputes lawyer, I can say with confidence that having to pay a lawyer to defend you when something goes wrong costs significant amounts more than paying a lawyer to look at it beforehand. And so that's a trade secret. Maybe I shouldn't be saying this, but the resources are available. So things, especially for the medium to larger charities, things like paying to do an internal audit every few years, that's important. Every now and then do a risk assessment exercise, get a professional to do a risk assessment exercise. When you have a large contract or something you're not sure about, get legal advice. So if you're well-resourced, you can do it. If you're not well-resourced, go online, look at the website, go talk to LawSoc Pro Bono and see whether you can do a matching for you. And use the resources. Don't think that you need to do everything in-house. Because sometimes these resources in governance will save you a world of pain later on.
Thanks, Paul. So I think our case scenario touching on when Sam was dealing with, I think, a click did touch a chord with some of the audience members. So I think just grouping together their query, conceptually, I think their question is, look, I'm doing my best. I'm speaking out, I'm disagreeing, but still, like it or not, I get outvoted. So am I responsible for decisions made by the majority, even though I've said I don't think this is the wisest course of action? Carla, what are your thoughts?
So this goes back to what Gerard said just now. Make sure that your views are recorded. So it's okay for the board to have differences in views. We're all not made the same way. And it doesn't mean that every decision that goes against you is a bad decision. It could be a very good reason why it goes that way. But if you're objecting, absolutely critical to be objective in stating your reasons and making sure someone records that reasons down. My biggest problem that I see with people that I work with is the reasons are never recorded enough. Okay, so it's not the disagreeing which creates the problem. It's the how do you justify why you disagree with, where's the evidence for that disagreement, and so on, that creates the problem. So if you have that and things do go wrong subsequently, you're still in a sense protected and you're not taken to have automatically consented as such.
Thanks, Carla.
Yeah, I want to pick up on what Carla has said. I think a lot of charities, actually in some corporate boards as well, when we confirm minutes, which is something we do in the start of most meetings, most people will just take a brief glance and then everyone just okay, minutes confirmed, and we move on. But actually, if there's a contentious subject and you're not so sure that your views are being recorded, that's where again, I repeat what Gerard has said earlier, going through the minutes and making sure that what is stated is accurate and it has properly listed out what you want to say is actually quite key. So don't take that minute confirmation exercise too lightly. If there's a disagreement in the board, especially with the governance issues, use that process because it's there for a reason, and use that process to make sure the minutes are accurate and complete, and they have actually stated what you have said in the meeting. And again, when it crosses a certain line and you think this is actually criminal rather than, say, a governance slip, then blow the whistle. Yeah.
Thanks, Paul.
I think, Serene, I like to add, especially for directors or online, very often you meet once a quarter and you're very lucky if you get the minutes of the last meeting 1 week before the next meeting. And most of us humanly will not remember the details of what was discussed at the last meeting. So if you happen to be on one of this board where it is a little bit more contentious, take copious notes. Because there's no way as a human being you're going to remember, especially those contentious points. Take copious notes for yourself, who said what was decided and all this, and that will help you to check the minutes when it finally arrives.
Serene, if I could just add one quick point. I think Paul raised an important point about the whistleblowing, absolutely critical. And it's a good avenue. Sorry, my apologies. It's a good avenue open to potential volunteers, to potential other directors on the board as well. Yet, please do be cautious. Because even as we whistleblow, and I really think it needs to be used, recognize that if you don't do it carefully, potentially there are defamation action suits and so on that you could be tasked with. So be careful. Just a cautionary note.
Thanks,
Completely agree. And apart from defamation, if you say something untrue, you might cause a lot of pain for a charity, and a lot of charities actually have ended up having to deal with board directors or staff members or volunteers who are unhappy at certain decisions, which are definitely not criminal. But we have spent a lot of time as boards having to clean it up, right? I'm sure some of you have experienced because someone's written a poison pen letter, or someone even out of, has whistleblown something which is actually untrue. So check your facts and take Carla's warning about defamation very seriously.
Thanks, Paul. Important reminder that it's not only just about your concerns, but do also please pay mind to the charity, the poor charity that's caught in the middle of all of this.
Correct.
So Carla, you had mentioned a little bit about shadow directors, and a question from the audience member is that, well, I guess their charity is a little bit less formal. So they just have a president, treasurer, secretary, that's it. Nobody's called director at all, formally at least. So are these counted as shadow directors, or are they just treasurer, secretary?
Usually, let me take a step back. And the treasurer, the secretary, are they employees of the company, first of all? Because it's not uncommon for, say, someone in management to attend the board meetings as secretary to the board, rather than a board member being assigned the secretary role. So that is something that we need to explore. Now, the person who asked the question, not off at all, because it is also common that I might have a board of directors and each one of us takes a different role. So I could have a president, a chairman, a vice chairman, a secretary, a deputy secretary, a treasurer, and so on. We call ourselves different things, but we are all board members. So first and foremost, you got to see whether you have been appointed to the board. And if you haven't, then the issue of shadow directorships come in. So if you haven't, then what influence do you have on the decision of the board as a whole? As secretary, are you driving the discussion and arriving at some kind of conclusion that the rest of the members all agree with? Or likewise, treasurer, or likewise, executive director, but who's not appointed to the board, and so on and so forth. If you are driving the decision in some way or other, then yes, potentially you are a shadow director. You've got to be careful.
Thanks, Carla. I think on this point, another audience member asked, it's very common for board directors, they take on additional titles, like as you said, treasurer, etc. So for the director who's named, let's say, treasurer, does he have additional or even more responsibilities compared to the others if it comes to finances?
Okay, my answer is yes. I like to simplify things, right? So I used to have this chart where I say, okay, you're a director, you have minimum amount of responsibilities. Then if I plus additional responsibilities, it means that it has to fall on you, right? Because you have taken on that additional responsibilities. And additional responsibilities potentially means more accountability, which then means if you do something wrong, possibly more liability. So it does follow. So in a for-profit, for instance, you have audit committee chairs. Audit committee chairmen or chairpersons will bear more responsibility when it comes to anything dealing with finances. So likewise, say treasurer, anything dealing with finances, because as treasurer, you're supposed to have charge of what's coming in, what's going out, and so on and so forth, right? I would think that you have more responsibilities and hence more liabilities. The only caveat I will add to that is I will go back to my policies and my terms of reference to see what does it say my role as a treasurer is and what's the limits to that role. If there are clear limits, then my remit is within that role as such. My liability is potentially limited to that. Now, everything I'm saying assumes that there's no hanky-panky or trying to do more than what you're supposed to and creating the responsibility. And then there will be additional liability as well.
Thanks,
can I add something to Carla's earlier point about shadow directors?
Yes.
I think one phenomenon we've been seeing quite a lot is charities forming subsidiaries, companies limited by guarantee. It's fairly new, but because you can do slightly different things with CLG, right? Or sometimes you need to hold certain property or run certain operations. And oftentimes the boards overlap, or you're not so clear who's the board member in the mother charity, who's the board member in CLG. And what normally happens is that you actually have one board meeting and all the CLGs are lumped together. Whether this is the best practice or not, whether it's practical is something I think each charity needs to think about. But that's the way the shadow director thing comes in also. Because if you are sitting on the board of the main charity, but actually it's this board that's directing all the actions without an independent board making your own decisions and all. You could very well be found to be a shadow director because you're sitting on the motherboard, but the board of the mother charity making all the decisions for the CLG. So that's becoming a fairly common phenomenon now. And I would say that the board of directors on the main charity, if they are making all the decisions for all the CLG or any subsidiary, you have to be careful and make sure that if you're acting as a shadow director in that way, then you have responsibility as well that gets tagged on. So that's something that I think that directors should watch out for.
Thanks, Paul. And they're very neat. These actually addresses one of the questions that's actually raised by the audience member, which was basically, he was on a charity and basically asked to sit on the board of various subsidiaries. And I think you encapsulate his concern, which is basically you have to kind of follow instructions from the mother company or the parent company, the head charity, So I think one thing you have to be aware of is that if everyone's involved in decision making, even if you don't officially sit on the board of directors of the subsidiary, you may be considered as a shadow director. Now, another interesting question and unfortunately this is the last question because we're running out of time, is that, we've talked so far about conflict of interest between director and the charity or director and the service provider. But how about director and director? So for this particular audience members, he has business with the directors professionally outside of the charity work, and perhaps that's even how they met each other. So is that considered a conflict of interest, given that it's between the directors and they're doing professional things outside of their charity work? Carla, any thoughts on this?
I'll jump in and then the others can add as well.
Sure.
Legally, again, I don't see a conflict legally, but the legal rules can only set that many parameters. But I would say, as a matter of best practice, it means that the second director has come in because of my relationship with him as such. So he's come on board. It is pertinent for me to make sure that I disclose that to my board as a whole, that I'm recommending this person to be a director. I do business with him. This is the kind of things that we do and so on. Be completely upfront with the board on that. And the reason for that is to avoid any subsequent potential arguments about cliques and so on, or that we are always sort of voting in the same direction, or potentially a contract subsequently being awarded to him and this being used as a basis as well. Links when something goes wrong, links can always be found to support that thing that's going wrong. And hence, disclose upfront, even though it's not a legal requirement to disclose. It's slightly different to a family member, right? Disclose, transparency.
Thanks, Carla. Gerard, Paul, anything to add?
No, I think Carla has put her finger on it. It's disclosure, it's transparency. So there are certain charities that form almost a little bit like a family foundation. We will find relatives, brothers and sisters and aunties all on the board. Probably less of a problem because everybody who is on their board knows the intent of it. But disclosure and just make yourself as transparent as possible so people who deal with it with you as an organization knows exactly the structure and how you are related. Yeah.
Thanks, Gerard.
Paul? Nothing much more to add, except that when you go to charities which start with foundations, or you go to small churches, for example, which are charities, you might have a lot of family members sitting on the board, and it might just be that pool of talent for a particular cause is so small that the people who volunteer are only that number of people, and we talk about renewal and all, but might be difficult. But in that case, I think then what needs to happen is that you need to make sure that disclosure happens. Disclosure. But for what is non-legal and slightly more sensitive to deal with is decision making. Because if, let's say, you have husband, wife, brother, sister in a board of 8, and there's a decision to be made, then maybe you got to think very carefully whether this is best for the charity, or do you end up with a group think. And it's difficult for small charities, and it's a struggle. But that's something that needs to be thought about quite carefully, and whether you then need to widen your net and say we on purpose want to move away from having all the same people over and playing musical chairs in this board. Yeah.
Thanks, Paul. We're sadly out of time, so I'd like to invite each of our speakers to just leave us with one key takeaway. Perhaps Carla, would you like to go first?
I guess at the end of the day, it's a point I made just now. If one lives life with complete transparency is very difficult to find for. So it's really about complete transparency with anything and everything that you do. And I know you said one thought, but know why you decide to volunteer, know why you're deciding to go onto the board. That is absolutely critical. Thank you.
Thanks, Carla. Paul?
We're talking about liabilities and it can be a bit scary, but I don't think anybody listening to this should let it stop them from serving. And even when it comes to governance challenges and you step up and say something has gone wrong and you make the difficult decision, should you whistleblow, should you raise things to a difficult chairperson or board, you are serving the charity, you're serving the public. Even in that, and that might be actually the most difficult piece of service that you have to do. That doesn't face all of us all the time, but in spite of all this, I would say charity work is wonderful, right? We're giving back, and I want to encourage everyone to keep continuing what you're doing and keep giving of your time and your energy.
Thanks, Paul, for an encouraging note. Gerard, what are your thoughts?
Well, I think ditto to everything that's been said, and I'll just add on to it, documentation. Keep copies of that critical email where you have raised objections and what was said. Keep it. I suppose the normal period is at least 6 to 10 years. You'll never know. And hopefully you are not called upon to pull it out to defend yourself.
Thanks, Gerard. And thank all of you. This brings our webinar to an end. After this webinar ends, a feedback form will pop up on your browser for your completion. We appreciate your feedback so that we can improve our future webinars. If your charity needs legal advice, please email us at assistmpos@lawsocprobono.org.sg. On behalf of Law Society Pro Bono Services, Charity Council, and the Commissioner of Charities,